Thank you all for joining us for this Race in the Law session. My name is Georgette Vigil. I'm the Senior Director for Alumni Engagement and Outreach. A few items to note: your screen name should be listed as your first and last name. If it isn't, please update your profile in video settings. Your first and last name allows us to identify you, so you receive credit and your CLE affidavit. You are invited to introduce yourself using the chat function by typing your name, grad year, where you work, or maybe where you're tuning in from this evening. Please note this is an interactive session. You can ask questions during the presentation using the chat function. Presenters will respond to questions following the presentation. After the Q&A, you will be randomly assigned groups to discuss the topics outlined in your program at cu.law/program. Now it is my pleasure to introduce the Dean of Colorado Law. Dean Anaya is an internationally recognized scholar and author in international human rights and issues concerning Indigenous peoples. He served as the United Nations Special Rapporteur on the rights of Indigenous peoples from 2008 to 2014. In addition to his teaching and scholarship, Dean Anaya has litigated major cases involving Indigenous peoples, human rights in domestic and international tribunals. Please join me in welcoming Dean Anaya.
Good afternoon, everybody. Those of you who have joined us for multiple sessions of our Race in the Law series could probably have memorized that introduction of me, but thank you, Georgette. I hope you're all doing well this beautiful afternoon. I know the beautiful weather outdoors draws us after, let's say, a winter that lingered on into the spring. So we're especially grateful that you're joining us. I'm quite confident that you're going to get a lot out of and enjoy today's session. This installment of our Race and Law series is titled When Black Lives Don't Matter. When Black Lives Don't Matter, years lost to wrongful convictions in the Black community. And it features Anne Marie Moyes, the director of our Korey Wise Innocence Project, and Anne England, whom many of you know is a clinical professor at the law school. Before I go any further, I want to recognize that the University of Colorado Law School sits upon land within the Ute, Cheyenne, and Arapaho peoples' territories. And I'd also like to celebrate the appointment of Lolita Buckner Innes as the next dean of the University of Colorado Law School. She is a renowned critical race scholar and feminist scholar, and she will be the first African-American dean in the history of the law school. She joins us from SMU Law School, and she'll take over as dean on July 1. And we're thrilled about her joining us. Now, let me say a few words about the Race in the Law series, which, and I know, again, many of you are already familiar with the series and its purpose, but let me just summarize that. The series is part of the Colorado Law's Anti-Racism and Representation Initiative. And our overarching goal of this initiative is to enhance opportunities for learning and reflecting on racism and its effects, and on what each of us can do to defeat racism as lawyers or future lawyers and citizens. Now, we're advancing this goal in part through this lecture series. Other goals of the initiative are to expand the law school's role as a catalyst for direct action to combat racism and its manifestations around us, and also to enhance the representation and inclusion of people of color and others from marginalized groups within our law school and the legal profession. If you're interested in learning more about the initiative and our progress with it, I encourage you to visit our website at colorado.edu/law. Before I introduce our speakers, I want to welcome Cynthia Sánchez, a recent graduate who will join us following the presentation to moderate the Q&A. Cynthia recently received her JD from Colorado Law. In law school, she worked for a variety of, during law school, she worked for a variety of nonprofits, including Youth Justice and the Northwest Justice Project. She also spent time working in civil rights at Kilmer Lane and Newman, and as a law clerk at the Colorado Attorney General's office. And she recently joined the Korey Wise Innocence Project as a postgraduate fellow. It's now my pleasure to introduce Anne-Marie Moyes, director of the Korey Wise Project, and England clinical professor. Their work with the Korey Wise Project is an outstanding example of the law school's public service mission in action. By assisting incarcerated individuals with credible claims of innocence, the project seeks to advance legal remedies for human error and systemic flaws in the criminal justice system. Now, this is work that all of us at the law school and all those who are associated with us can be immensely proud. Tonight's speakers are responsible for the ongoing success of the project and for engaging our students in it in ways that benefit them immensely. Each one of our speakers' extraordinary passion and dedication to this vitally important work, and that will be evident to you this evening. Now, I'm not going to go into the biographical information because you have their detailed biographies in the program. So it's my pleasure to now present to you or turn the program over to our featured speakers. Anne-Marie, Anne?
Great. Let me get this started. I have to ask them, am I muted? Oh no.
You're good.
Am I muted? Oh, okay. I couldn't tell. Good evening. Criminal law is the way that we enforce our values. And when we examine it, we can see who we are. The story of the African American is not only the quintessential American story, but it's really the story that continues to shape who we are today. This is a quote from Lonnie Bunch III, who was the secretary at the Smithsonian Institute, and also is a quote that's found on the wall of the African American History Museum in Washington, D.C. When we think of Black Americans, African Americans who are innocent, who have been wrongfully convicted, there is no other place that we can start this discussion but by looking and thinking about slavery. For there is no larger group of Americans or African Americans who have been wrongfully convicted. Because remember, slavery was legal, and the way that we enforce that was through our laws. This legal method or legal enforcement was called the slave codes. And the slave codes were a way to punish slaves for doing things that were innocent. Things such as trying to own property, getting married, trying to assemble or gather in a group without a white person present, practicing their religion, traveling. They could not travel without permission, protecting themselves from injury, protecting others, protecting the people they loved, but maybe most importantly, keeping them from leaving. And it is these codes and laws that we are going to look to just a little to look for the strings that attach to our modern justice system that will hopefully give us some kind of context where we can look at why race matters so much in wrongful convictions. The sentiments that were found in the slave codes can still be seen so clearly in our American justice system. From lynchings to the modern death penalty, from images of slave work gangs to prison work gangs, from slave codes to Jim Crow laws to modern drug laws, from the forced transport of millions of Africans in chains to enslaved African Americans sitting in chains in courtrooms across America. We have not changed many things. We may call it different things, but criminal justice is one that is inextricably tied to our legacy of slavery. Now, that could be a lecture in itself about following the path from the slave codes to the Jim Crow laws to our modern drug wars, but we're not going to go there today because there's so many other things to talk about. Instead, we are going to look at wrongful convictions in what we call the modern age. And we're going to look at cases and look back at the cases where they have found people wrongfully convicted and look at the factors that have led to those wrongful convictions and pull out those strings that we can see from the past in them. And with that, I'm going to turn it over to Anne-Marie to start.
I think you need to unshare. So, okay, there we go. Okay, so as Anne said, well, you know, what we're going to turn our attention to now is wrongful convictions in the modern era, meaning since 1989. So there are some organizations within the US, including the National Registry of Exonerations, which is a joint project of the University of Michigan and the University of California at Irvine. And they make their work to be studying every exoneration in the United States and then reaching different conclusions and drawing different data points from that set of wrongful convictions. So in the last few years, they actually issued a study on race and wrongful convictions, and these are a couple of their global findings from that study. So if you look at the full body of exoneration since 1989, nearly half of all exonerees are Black, just a staggering number. A staggering percentage. Black people are 7 times more likely to be wrongfully convicted of murder than white people. A Black prisoner serving time for sexual assault is more than 3 times more likely to be innocent than a white sexual assault convict. Black people are 12 times more likely than white people to be wrongfully convicted of drug possession. We also know that the race of the victim matters. Black murder defendants are more likely to be innocent if they were convicted of killing white victims. Black exonerees spend 3 to 5 years longer in prison before release than their white counterparts. So these are just some big picture statistics that give us a sense of these stark racial disparities. And when we start to think about why, you know, I want to first kind of zoom out and look at our criminal justice system as a whole and think about how often does this happen? And then when you look at just disparities in the larger system, how does that alone explain some of the disparities illustrated in these stats right here? There are reliable studies by legal scholars that suggest that wrongful convictions occur in as many as 5% of criminal cases, a 5% error rate. We tolerate an error rate that high in our criminal justice system. And, you know, as we all know, in this country, we have a system of mass incarceration. So we have this high error rate, and then we have this high error rate in a system of mass incarceration that itself is infected by racism. I'm sure many of you have seen these statistics, but seeing it in graph form is just so striking to see this policy choice that we make as a country where we have the highest incarceration rate in the world. And a rate that's just dramatically higher than in other democracies. And then when you drill down and you look at that incarceration rate by race, we see just, again, staggering disparities, where you see the rate of incarceration for white Americans is 450 per 100,000, and that skyrockets to 2,300 per 100,000 for Black Americans. So what we're going to talk about for the rest of our talk today is beyond those kind of big picture explanations of how, the racial disparities in the broader system kind of are a big explanation. We're going to try to look at what do we know about wrongful convictions as a whole, what the contributing factors are, and how race might be baked into some of those contributing factors. So again, the National Registry of Exonerations that tracks this full body of all exonerations since 1989, what they've done is they look case by case and they identify some of the common features we see in cases of wrongful conviction. And they've come up with these statistics of these kind of overlapping contributing factors. In other words, you often see more than one of these factors in a single case. And what we know is that perjury or false accusation is a factor in nearly 60% of wrongful convictions. Official misconduct in nearly half of cases. So within official misconduct, we would count both prosecutorial misconduct and police misconduct. Mistaken eyewitness identification is a factor in nearly 30% of cases. Inadequate legal defense in 25%. Flawed forensic evidence in about a quarter of the cases. And false confessions in nearly 13%. So the rest of our presentation, what we're going to do is look at some of these factors and then just examine what role race plays in these factors through telling you some stories of individual cases of wrongful conviction.
Switched. So I'm going to talk a little bit about what we're calling, or what's been called, official misconduct. And as Anne-Marie just said, there's found to be 45% of cases studied, there was some sort of official misconduct. In terms of police misconduct, there is a significantly higher rate of police misconduct found in cases where there are African Americans. And then within that, we're going to focus on a few of the areas of that. So in 17% of prosecutions that led to exonerations, government officials improperly induced witnesses to provide false evidence or withhold accurate evidence. And this generally falls into two categories: threats or manipulation. So threats are things like, if you don't say this, you're going to lose your job, you're going to go to jail, you're going to be punished yourself. Manipulation, you can imagine promises of leniency, better conditions in jail, not going to jail, money, sex, drugs. And some people are manipulated to the extent that they believe they saw something that at the beginning they knew wasn't true. One of the cases that we're going to talk about tonight is the case of Sharif Cousins. I'm not sure if some of you got to come to our fundraiser a year ago in the spring before all this started. And Sharif was generous enough to come out and tell his story to a group of people for a fundraiser for the Innocence Project, for the Korey Wise Innocence Project. Sharif Cousins was 16 at the time of the crime and 17 when he was sentenced, and he was sentenced to death. He was the youngest person ever convicted in Louisiana and sentenced to death, and one of the youngest in the United States. The case involves a man named Michael Girardi, who was out on a date with a woman named Connie Babin, and they went out to dinner. When they finished, they were in Louisiana and they were in New Orleans, and they were walking down the road, and three young men came up to him. Girardi told Connie to run, and she did, and he was shot and killed. There was no physical evidence, and prior to trial, Connie had told the police and prosecutors that it was dark outside and that she could not get a good look at the gunman or the other people because of the distance, the darkness, and she would not be able to identify him. She also stated that she was not wearing her glasses on the night of the murder and could only see shapes and patterns. However, when she got to trial, she identified Mr. Cousins as the shooter. And what's unfortunate about this case and shows the police misconduct is that information that would have been critical to the defense was never turned over and never given to the defense so they could use that to discredit her testimony. And the second kind of police misconduct in that case is possibly even a little more egregious, if you could believe it. That night, Sharif was at a basketball game. He was on a high school basketball team, and they were playing a scheduled game. And not only was there a videotape of that game, all his teammates were there and his coaches. And during trial, Sharif and his lawyer brought those people in, and they were sitting in the hall waiting to testify that night. But while the case was going on, a police officer went out and spoke to these witnesses and told them that they should sit somewhere else. They should go back into a different room, and took all of the witnesses into another room. Then it was the defense's turn, and they went to go call their witnesses, and they couldn't find them. And they couldn't find them for a period of time. And the judge finally said, well, I don't know, I guess they left, they aren't here, and moved on. And the jury never got to hear the testimony of all of his alibi witnesses, and he was convicted. So that's one type of, two types actually, of police misconduct. Another type of police misconduct that happens is what's called coerced confessions. And I think you saw this kind of comes in two ways, and that's where it shows the overlappingness of some of this. Coerced confessions, it's police misconduct, as in this case, and it's also false confessions, where you saw a percentage of the cases had false confessions. This is the case of Byron Halsey. Byron Halsey was raising two children with his girlfriend. They were not his children, but he was caring for them. And on the night of this crime, a friend of his named Clifton Hall came over to his house and convinced Halsey to go over to some friends' houses, and eventually left him there to hang out with those people, and left. When Halsey got home, he found that his children were missing, and they were eventually found murdered and sexually assaulted. Both Hall and Halsey, who were the last two people to see the children, were arrested. Halsey was interrogated by police for 40 hours and eventually confessed to the crime. What they found out about Mr. Halsey is that he only had a 6th grade education, and he had several significant learning disabilities and cognitive disabilities. And this confession, as they later found out, was marred with inconsistencies, inaccuracies, and just purely made up facts. And this was never disclosed. The confession was never taped. It wasn't recorded in any way. And the notes, which were later found by the defense in helping him during his exoneration, were never disclosed to them. He was eventually, after being in prison for almost 20 years, his conviction was overturned when they tested the DNA and found out it was in fact Mr. Hall who had committed the crimes. But that's not the only way and the only lens to look at police misconduct. I'm sure many of you heard about the case of Detective John Burge when it came out into the press, because it was a really big deal in Illinois. Detective John Burge was the head of a major crimes unit in Chicago, in the Chicago Police Department. And between 1972 and 1991, he tortured more than 200 innocent men into confessing to crimes that they did not commit. Those men were tortured by being beaten, suffocated by plastic bags, burned, having electrical shocks attached to their genitals, being chained to radiators for hours until they confessed to crimes that they did not commit. What was shocking is it wasn't just Mr. Burge who was involved in this, or Detective Burge. It was a unit of police officers who covered up for him systematically throughout the 90s and the early 2000s, until finally he was in the 80s and 90s. He left in 1991. So many people wrongfully convicted based on his actions that they created something called the Illinois Torture and Relief Commission. And the city of Chicago ultimately is paid up to this date up to $662 million in reparations for literally several hundred years of lost time to the victims he forced confessions from. And not surprisingly, but very sadly, the majority of these people were Black. And in speaking about police misconduct, you can't walk away from another category that's actually not included in most of the literature that we look at when we're looking at wrongful convictions. And that is wrongful convictions in mostly drug cases. I think as we've heard kind of Spates here, and I'm from Philadelphia, and there were two big exposures or times that police officers were actually arrested for crimes. But I think in looking at this chart, what I find overwhelming is looking at the racial and ethnic identity of the defendants who were wrongfully charged and convicted in these cases, and just seeing the word overwhelmingly Black just be repeated and repeated. And in these cases, again, it was not generally one rogue officer. Now, there's a few of these, that's true, or lab technician, but it really was a team of officers who came in and did things such as planting drugs, hiding guns. I pulled out one story, of course, focusing on Philly, because that's where I'm from, of a detective named Detective Jeff Walker, who was a narcotics detective in Philadelphia, and was actually, this went on when I was living there. And just for an example, he arrested a young lady named Brittany Mills, who was 19 at the time. She had just gone to her boyfriend's apartment, and the police busted in and went into his freezer and said they found a brick of cocaine. All the occupants said, "That's not mine." And for some reason, only she was charged. She got 5 days in jail and a year and a half of probation. And now that may not seem like the years and years that these other people got on these other crimes. But what happened to her afterwards was significant. Because her father then believed she was dealing drugs, she got kicked out of her house. Her work learned about it, she got fired. She lost custody of her 3-year-old daughter, and she became homeless. And all of this happened because a few weeks prior, she had had an altercation with Detective Walker, and he had told her that soon she would find out what would happen if she was so smart with officers again. So it's not just the police that overstep their boundaries, it's also the prosecutors. And the two main ways that they have been found to do this is by concealing exculpatory information and by misconduct they have at trial. So I thought we'd go back to some basics, but under the American Association Standards for Prosecution, the duty of a prosecutor is to seek justice within the means of the law, not merely to convict. And this is the Colorado Rules of Professional Responsibility that are special rules for prosecutors. And one of the things they must do is make a timely disclosure to the defense of all evidence or information that is, all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. And in connection with sentencing, disclose to the defense and tribunal all unprivileged mitigating information. So that means that they need to turn over everything. It is their ethical duty. And that is something that happens and doesn't happen. And I think you can go back to the case of Sharif Cousins. You can go back to all of the cases I've listed. And one of the hallmarks of that is that prosecutors and police are not turning over the information the defense needs. So the other thing we wanted to highlight was that it's not just before trial, it's during trial. Prosecutorial misconduct happens at that point. And I'm going to illustrate that by telling you the story of Samuel Bonner and Watson Allison. Both of them were charged with robbery and with felony murder for entering the home of Leonard Polk. Although witnesses only saw Allison enter the home and come out several times with many items, the prosecutor, Kurt Seifert, who was in Los Angeles County, alleged that in Bonner's trial, who was tried first, alleged in Bonner's trial that it was both men who went into the apartment and both men who were involved in shooting and killing Polk. Bonner was tried first, and during that trial, Kurt Seifert came in and argued that it was actually Bonner who was the trigger man, and it was Bonner who had arranged the theft. During that trial, he relied in part on a witness, Mr. Haynes. And Mr. Haynes was a jailhouse snitch who said that Mr. Bonner had confessed to him. And during trial, the prosecutor realized that Mr. Haynes, in fact, was lying to him. He realized that slowly through some misstatements that Mr. Haynes made, changing his statement from what he had told the prosecutor earlier, and he didn't disclose that. But most significantly, he learned during the trial that Mr. Haynes was not Mr. Haynes, that Mr. Haynes was in fact a man named Carter Jones, who was a serial liar and a serial snitch, that he was wanted in another state for lying in a different homicide trial. And none of this was ever disclosed to defense during trial. It wasn't disclosed till much later. But back to other problems. Later, Mr. Bonner was convicted and was sentenced to death. Later, in Mr. Allison's trial, the same prosecutor came in with the same evidence and argued that it was Mr. Allison alone who entered the apartment and shot and robbed Mr. Polk, and that Mr. Bonner was merely a driver. When confronted with this in court during a trial much later on perjury, he said, well, boo-hoo. You can quote me when asked why he accused Bonner as the triggerman in the first trial, and then Allison in the second. He admitted without any embarrassment, the switch was just the big oops. So I think as you can see, prosecutorial misconduct and police misconduct is a serious problem. And in all of these cases, as you can see there with African-American defendants. Oops. So Emery, you want to take it back?
Now we're going to switch to flawed forensics. Can you guys just let me know? I think that we're both sharing at the same time now. Did that slide switch to flawed forensics?
Yes, it did.
It did. Okay, thank you. Okay. Okay, so, in the past 10 years, there's been growing scrutiny on the state of forensic science in the United States and its reliability, which is a subject for a whole other 1-hour discussion. But what I want to talk about today in terms of forensics is cognitive bias in the interpretation of forensic evidence and how racial bias might itself play a role in interpretation.
Hey, Emery, you may want to put it to slideshow mode because it's showing.
Okay, thank you. Okay, did that work? Yes, thank you.
Perfect.
Okay. So to understand how cognitive bias or racial bias would come into play in the interpretation of forensic evidence, let me just spend a minute talking about what a lot of forensic analysis looks like. Most forensic disciplines involve comparison of patterns. And so on the left here, you have an example of 2 fingerprints. And the print on the left is what we call a latent print. It's a print that was lifted from a crime scene. And then it's compared to the image on the right, which is an actual suspect's print. So you see on the left, a print of not as good quality. Typically prints lifted from a crime scene are partial prints, and they don't have the same clarity as this very perfect print that would be taken from a suspect. But what an examiner does is they look at the prints side by side under a microscope, and they look for similarities or inconsistencies, or what you would call discrepancies. And if they find a certain number of similarities, they will say that they came from the same source. If they find a discrepancy, they get to make their own rather subjective determination about whether there's a reasonable explanation for the disparity, like smudging, or if the disparity actually is a reason to conclude that the 2 prints come from different sources. The image on the right is an example of tool mark analysis, where you can kind of see this faint line in the middle of the screen, and you see the image on one side is of a bullet that was found at a crime scene, and then on the right you see an image of a bullet test fired through a suspect weapon. And again, what you have an examiner doing is looking at these striations on the bullet that are caused when a bullet is fired through a chamber, and the examiner is making a determination whether the patterns essentially match or whether they don't match. So that you can see it's pretty obvious that there's some amount of subjectivity in making those determinations. So what cognitive scientists have been studying is determining to what extent different kinds of cognitive bias affect that interpretation. And what they've come to understand is that what we see is affected by what we hope or expect to see. So I want to tell you a story about an experiment that a neuroscientist named Itiel Dror did. So first, let me tell you a little bit about this crime, the Madrid bombing that happened in 2004. It was an awful terrorist bombing that killed 193 people. And some of you might remember having heard about this, but the law enforcement found a bag near the bombing site, and it had different parts for making bombs in it. And they were able to find a print on an item from that bag. And you see on the left, this very distorted print that they were able to lift from these bomb components. And what they did is law enforcement ran those prints through an international database of prints. And the database gave them 10 possibilities of individuals who might be a match to the print. And the FBI determined that they believed that Brandon Mayfield was the source of the print. Mr. Mayfield was a lawyer in Washington State. His prints were in the database only because he had previously served in the military. But he was a lawyer. He had converted to Islam in adulthood, and he had recently represented another Muslim American in a case involving allegations of terrorism. And so for the FBI, he seemed like a good fit to be involved in the bombing. But it quickly became clear that he could not be the person, he could not have been involved. And in fact, international law enforcement disagreed about the print interpretation and believed that there was not a match between this crime scene print and Mr. Mayfield's print. So it became this kind of notorious case in the forensic community of a mistake that was made in fingerprint analysis. And it was, widely covered in the media. So what Mr. Dror did, the neuroscientist, is he contacted 5 print examiners. And he says, I would like for you to review the prints in the Mayfield case. So from the perspective of these 5 examiners, they believed they're looking at the prints in the Mayfield case, an example of a false match, a false positive. And of the 5 examiners, one expert said, well, I would declare this a match. One said he would find it inconclusive, and 3 experts said that they would find no match, that they did not believe it was a match. But what Mr. Dror didn't tell the 5 examiners is that in fact, he had not given them prints from the Mayfield case. He had given each of them a set of prints from a previous case where they had testified in court and declared confidently that it was a match. So when they believed that they were looking at the false positive print from the Mayfield case, they reached one conclusion that was the complete opposite, at least for 4 of the 5, of what they had actually testified to in one of their prior cases. So this is just a great example of this phenomenon. What we see is affected by what we hope or expect to see. It's a great example of cognitive bias. So next I want to talk about racial bias and how it similarly could play a role in how forensic examiners interpret evidence. And I'm going to talk about another study done by the same neuroscientist, Itiel Dror. So in this other example, what Mr. Dror did is he considered the work of medical examiners. So, this is something most of you are probably familiar with, that medical examiners do autopsies and they determine cause of death. And if they determined that the cause of death was homicide, then typically criminal charges would be brought. So their determination, ends up making the decision about whether somebody faces charges or not. So the first thing Mr. Dror did is he looked at 10 years of medical examiner records in child deaths in Nevada. And what he found is that medical examiners were twice as likely to rule a Black child's death to be a homicide as compared to when the child was white. And then he did a study kind of similar to the one he did in the fingerprint example. He contacted 133 medical examiners, and he gave all of them the same medical information, but he gave half of them one vignette about the background details. He gave the other half a different vignette. So half of them were told that the child was Black and had been in the care of the mother's boyfriend at the time of death. And the other half were told that the child was white and had been in the care of his or her grandmother. And that radically changed the findings. The examiners were 5 times more likely to rule the Black child's death a homicide, even though the medical information was identical. So again, I think these studies are really important, and I think we're just, it's great that this research is starting to be done, but it's really disturbing what the findings are. So now I'm going to switch gears and talk about another of the contributing factors. If you remember the slide from earlier in the presentation, the National Registry of Exonerations has found that perjury and false accusations were a contributing factor in close to 60% of wrongful convictions. So I'm going to tell you the story of two different cases that show different ways that this can happen. So in the first case, it's an example of police misconduct, but specifically with respect to manipulating witnesses. Jabbar Collins was wrongfully convicted in New York. He was convicted of killing a rabbi during a robbery. The rabbi had been out collecting rent, and that's when he was robbed and killed. And the state presented 3 witnesses at trial. Adrian Diaz was an eyewitness who said that he had seen the perpetrator putting a gun into his waistband and fleeing the scene, and he identified Mr. Collins as that man. Angel Santos was another eyewitness. He said that he had been calling 911 when the perpetrator fled past him on foot, and he also identified Mr. Collins. And then Edwin Oliva testified that Mr. Collins had told him ahead of the crime of his plan to rob the rabbi. So Mr. Collins was convicted of second-degree murder and sentenced to a long term in prison. And while he was there, he actually investigated his own case. He figured out how to make public record act requests, and he even contacted some of the witnesses himself. And this is what he found out. So Adrian Diaz had actually just recently violated his parole at the time the crime happened. He had traveled to Puerto Rico in violation of the terms of his parole and was facing a return to prison. And the DA promised to make sure his parole would not be violated if he testified against Mr. Collins. That deal that was struck with Mr. Diaz was not disclosed to the defense. What Mr. Collins found out about Mr. Santos, he actually requested the 911 records and found out that Mr. Santos never made a 911 call. At subsequent testimony, Mr. Santos admitted that he was a drug addict at the time and was a heavy user, just in that time period. And also, what is maybe most disturbing is that when he told the prosecutor that he didn't in fact want to testify, he was jailed as a material witness to pressure him. And then when he agreed to testify, he was moved to a hotel until trial. And again, none of that was disclosed. And then with Mr. Oliva, he admitted that he only signed a statement implicating Mr. Collins after he himself was arrested on an unrelated robbery. And detectives threatened him, and he still didn't want to cooperate and tell this lie. But when he didn't succumb to their threats, they violated his work release and took him into custody until he cooperated. And then he too made a deal with the police where he got a reduced charge in his own pending robbery in exchange for his testimony. And again, none of that was disclosed. So again, it just shows here both the power of the police to exact this kind of pressure on witnesses and the utter disregard that they often show for the truth. So the next case I want to talk about is really different, and it echoes in a really dark chapter of the history in this country. We all know about cases like the Scottsboro boys, where in that case, a white woman just completely fabricated an allegation of sexual assault against a group of young Black men or even children, teenagers. And many of us want to think that chapter is long behind us, and cases like Mr. Hudson's show that it's not. So in 1999, a white teenager named Robert Gumpright reported a robbery. He had actually been on his way home from working as a bartender. And when he got home, he told his father that he had been robbed of $80 in tip money and a St. Christopher's medallion that he always wore. He gave a specific description of the perpetrator. He said it was a Black man who was 5'8" tall, 140 pounds, and he described his clothing in detail. 2 months after the crime, the police showed him a photo array, and he picked out Mr. Hudson's picture from the array and said that that was the man that had robbed him. At trial, the only evidence against Mr. Hudson was the testimony of this 18-year-old Mr. Gumpright. And Mr. Gumpright really made a great witness, because he said that in his work as a bartender, he really had to know how to remember people's faces. And he said, I am 110% sure that it was Mr. Hudson who robbed me. At that time in Louisiana, you could be convicted even without a unanimous verdict. So the jury voted 10-2 to convict, and Mr. Hudson was sentenced to 99 years in prison. But then 20 years later, the Supreme Court issued a new decision saying that verdicts must in fact be unanimous. And so Mr. Hudson was going to get his conviction overturned. So he was actually on the verge of reaching a plea agreement with the state where they would vacate his conviction, and then he would enter a new plea to robbery and be sentenced to time served. And just weeks before he was about to enter that plea, the district attorney's office got a call from a counselor at a drug treatment facility who said that Mr. Gumpright, the alleged victim in the case, had admitted during treatment sessions, during counseling sessions and treatment, that he had completely fabricated the crime, and that he had been afraid to tell his father that he had spent all of his wages on drugs. And so he made up this story of having been robbed. And then when the police showed him the photo array, he randomly picked out Mr. Hudson's picture. So just this month, in April of 2021, after serving 21 years in prison because a white teenager didn't want to tell his father the truth about how he had spent his wages, Mr. Hudson was released from prison. Oh, you're muted, Anne. Oh, I think you're still muted.
There we go. I said finally and very quickly, because I know we're running out of time. We're going to run through this last one without much ado. We left eyewitness misidentification to the end, even though it is a significant cause of wrongful convictions, and especially, I think, as you saw at the beginning, in African Americans. But we figured this is the one people had heard the most about. Can you go to the next slide? And the biggest problem with eyewitness identifications is really in cross-racial identification. It turns out that we are terrible as a group at identifying someone of a different race. Many cases that we've seen and we've heard of are really built on a single identification. And when identification is across racial lines, it can lead to some very disastrous results. But wait, you say, I'm really good at identifying faces. And the person was paying very careful attention. They told me they were, especially in significant crimes like sexual assault, where two people are very close together. So how is this possible? And again, there are so much stuff written on this that we're not going to go into details. But one part that I thought was really interesting about it is that when we tend to see people of our own race, we see their face holistically. And when we see people of other races, we tend to see individual features. So when someone's looking at a photo array or a photo lineup or even a live lineup, as opposed to look of a person of a different race, as opposed to looking at their whole face, and that's how our brains save people's images, we look for features that we may have seen before. So where you'd say someone has this kind of lips or this kind of eyes, someone will look for that because that's what they remember in a cross-racial identification, and not actually be able to remember that whole face. And the other piece to remember is that as identifications go, we tend to get more and more confident and not less confident. And part of the reason is that is just our system. You know, the victim sees the prosecutor follow up and charge someone, and they see the case moving forward, and that encourages people to feel more confident. In many cases that I've tried where I've talked to people, they said, but I thought I mean, they went forward. Of course, they had more than me to do this. There had to be more, without realizing what an impact one person's identification can be in court. We encourage you to look. There's a really great video that's about Ronald Cotton's case, where he and the victim are together and they talk about the case, because that was a case where he was wrongfully identified by the victim 3 times, right? If I'm not wrong. So can you go to the last one?
Yes.
So finally, I just wanted to have a couple final thoughts that ties together what we talked about, or I talked about at the very beginning, starting with the slave codes to now, and leave you with 2 very specific ideas. 2 of the things that come out of the slave codes that I think you can see represented in a lot of the cases we brought up today is Black people and people of color not being heard and not being believed, and people of color being treated harshly and mistreated. So if you think of 2 specific slave codes, one was that literally a Black person's voice could not be heard in court. Under the slave codes, if a Black person was not permitted to testify in court or even come into court. And secondly, if there was a question between a white person's voice and a Black person's statement, the court had to find that it was the white person who was telling the truth. Secondly, I'd ask you to think about the law or the code that made African Americans and Black people property. Because what is property? Property is something that you can abuse, that you can beat, that you can mistreat, that you can hurt, and that you can disbelieve, and that is not to be believed. And I think if you look back at some of the themes that we've seen in all of these tragic cases today, there's so many of that. African Americans' voices being silenced, that they aren't believed when they're saying, I didn't do it, I wasn't there, that their witnesses are taken away, that they aren't given access to the information they need to defend themselves, and that they're really treated like dispensable property. So with that, we want to thank you for coming tonight and being a part of our discussion. And we hope that as we move into breakout groups, we can talk about this some more. Let me just say one more thing. I want to use this second to say thank you to Dean Anaya, who has been our dean for the last 5 years, and for his leadership in this area that I know Anne Marie and all of the Korey Wise Innocence Project find so important in our work on racial justice. And thank you for helping us have Cynthia work with us. And we have 2 postgraduate fellows right now, Deshaun Parker, who couldn't be with us because he's actually in his graduation ceremony from law school right now, who's graduating and has already joined us, and Cynthia Sánchez, who will be leading this next section of this. So thank you.
Thank you so much, Anne and Anne-Marie, for that excellent and informative presentation. At this time, our presenters will be taking some questions. Go ahead and use the chat function, and we can get started with that. In the meantime, if there's any other thoughts that you, Anne or Anne-Marie, would like to share while we get the questions going.
Problem is, we could go on and on. We're timing ourselves clearly not well enough. Anne-Marie, anything you want?
Sorry, I got distracted for a second. I was reading the comments from before. I didn't realize our slides weren't working at some point. So
Oh, sorry about that.
Yeah, we were struggling with the technology a little bit. But I missed, could you repeat that, Anne, what you said?
Oh, so I mean, I could tell you Ronald Cotton's story if that's of interest to folks. Because I think what's marked about Ronald Cotton's story, if we have a couple more minutes, is that it really illustrates pretty well some of the misidentification problems. When the victim, Jennifer Thompson, and she's been very out in the media, so in saying her name, I'm not saying something unknown, that they noticed that she had never seen someone who's so composed and so determined. And that she really, during this ordeal that she went through, she spent energy thinking she was going to remember the person who did this to her. And when she came in, she very quickly picked the person out of the lineup and said, that's my rapist, that's him. And she was very certain that it was Mr. Cotton. Mr. Cotton was about the same age as she was. He lived in town and he had already been in trouble with the law. When he was arrested, he was nervous and his statement was a little fuzzy about where he was at the time. And there was some very circumstantial shoe evidence, a shoe print that they said that matched it. And she was so confident. And when she came into court, she immediately identified him as the attacker and without hesitation. And then there was a second victim who actually didn't pick him out at the first trial, and then the case was overturned. By the second trial, the second victim also was identifying Mr. Cotton, and again came in and pointed to Mr. Cotton and said that he was the person who did it. And there was DNA, but Anne-Marie, correct me if I'm wrong, that DNA was corrupted at the beginning, and it wasn't until the technology improved significantly that they were able to definitively prove that it was not Mr. Cotton. And eventually the district attorney's office, after the DNA results, confessed the motion. And I think what's been amazing about that story in so many ways is that it was this cross-racial identification, and Jennifer was so certain in what she said and who it was, and that she felt she was, and truly was, I'm sure, being so careful trying to remember this person during this horrific ordeal. And yet she was still wrong, and drastically wrong for this now older man. If you ever want to see a really compelling and moving video, they have done quite a bit of work together where they talk about this issue, and they're actually fairly close as people at this point. I don't know, Anne-Marie, you want to add something? I know you've taught about that.
Yeah, I mean, it's a really interesting case. I think, I mean, there are a couple other things. They did write a book together that's called Picking Cotton that I would recommend. And I think there was also a Frontline special called What Jennifer Saw that highlights their case. That's really interesting. But I mean, I think what that case also illustrates is a different kind of phenomenon about eyewitness identification is, you know, how we don't have a fixed recording in our head about what happened, and, you know, that our memory is really contaminated. So Jennifer, you know, she sees Ronald Cotton's picture, and then his image over years becomes incorporated in her memory of events, and she becomes increasingly confident it's him. And at some point later, when the real perpetrator is identified and she sees him, she really struggles to accept that this is the person that did it, because his face does not at all resonate with, you know, this imprinted, this like evolving memory that she's developed about what happened. So it's a really interesting case, and they've both become really great advocates for reform.
Thank you for sharing that. Okay, it looks like we have 2 questions here. We'll start with Eric W. And his question is, would you mind touching on the use of polygraphs, including questionable validity in assessing defendant's guilt or innocence?
Do you want me to? I can.
Sure.
Do you want me to? Okay, so I mean, polygraphs have universally been unaccepted for so long. And yet they are used not that much anymore, I think, but they were definitely used as a tool for confession. So they would bring people in and they would strap them up and say, okay, we're going to know if you're telling the truth. And they would, you know, and they would tell people, and essentially that was a coercion tool that they used to have people confess. But they've just not been accepted in courts. Now, I know there is some new research out there that suggests there's a much more sensitive polygraph, but because of the history of the use of polygraphs, I know at this point it is not being accepted into courts. So I guess that's as far as I can go. I don't know a ton about the new technology that's being used, but I think we have to remember that, you know, when people are arrested, they're terrified. And so some of this judging whether someone's lying based on how their heart rate and an increased heart rate and all of that can just leave a terrible falseness to it. So, but it has been used extensively in coerced confessions or in confession cases. Go ahead.
Okay, and then we can go ahead and answer this next question before we do the breakout groups. Kim asks, are these widely known and shared with the prosecutors and judges, referring to the statistics you all shared? And are these steps you are aware that are being taken into consideration and mitigating racial bias in conviction?
So I can answer that. I mean, I have 2 thoughts in reaction to this question. If we had had more time in this presentation, one of the things that I would have wanted to talk about is, why do we tolerate such a high error rate in our criminal justice system? And to what extent are we really trying to reform it, given everything that we've learned about wrongful convictions? And I think if you really dig into that question, that I think it's hard not to reach the conclusion that race and class do have a lot to do with us tolerating this high error rate and not being very quick to make reforms. And so, you mentioned in your question, are these statistics widely known and shared with prosecutors and judges? I think everybody knows at this point, what a lot of these statistics are, but is there a will for significant change? That's like a really different question. And often, a lot of the things we're talking about, especially with the misconduct, is really done with impunity. And we, that it's much more rare that there's accountability for the kind of misconduct that we've discussed. And we're also slow to be trying to make reforms that would promote greater accountability. So, I think there's very slow growth in the right direction. But, in the meantime, we still have all these systems in place that make these errors just way too likely.
And I would just say that, for one example, there's been a big push to change how photographic lineups are done. There's a lot of evidence that not having a photo array, but instead having a sequence, meaning you show someone one photograph at a time, is a much more accurate way to have someone pick it out. But police are just really unwilling to change because people are a lot less likely to pick someone out at all, because it's a really different process for your brain versus which of these 6 did it. And if the police do have other evidence that the person committed the crime, strong evidence that the person committed the crime, and then the witness doesn't pick out the person in the way that they do it, then it becomes a significant hardship to their otherwise fairly solid case. And so there's a big hesitation to try and change it, because just purely picking out anyone is just harder when you're only looking at one face and you don't know when it's going to end. It's actually a very different skill, right? Which of these 6 versus which person is it? And so you see kind of commonsensical ways why police are pushing, or prosecution push against some of these reforms. But when you see it go badly, boy, you see it go badly, right? And that's the places where, again, when Anne-Marie's talking about error rate, that it's really a struggle. So there are pushes for reform. And I applaud the law that was passed this last session about holding police accountable for the actions that they take.
Thank you for answering those questions. We're now going to move our conversation to the breakout groups. Before we do, though, I would like to remind you that by the end of next week, you will receive a link with the presentation and a survey so you can share your feedback. And for Colorado attorneys, you will also receive a link for the CLE affidavit. We're now going to move to the breakout session, and we will receive a 2-minute warning when the session is over to end the interactive session. Thank you.